Hey folks, I'm attorney Andrew Branca for Law and Self-Defense, and I'm really excited to share with all of you a recent lengthy interview of yours truly by CCW Safe as a kind of wrap-up of my thoughts about the Kyle Rittenhouse trial. Many of you will know that CCW Safe is one of our long-standing partners and an organization I think a great deal of. In fact, I'm personally a member of CCW Safe, as is my wife, Emily. If you're already a member of CCW Safe, you might want to just skip forward in this video to the timestamp over my shoulder, which is where the actual interview begins. But for any of you not already familiar with CCW Safe, they are a provider of legal service memberships, what many people mistakenly call self-defense insurance. CCW Safe, in effect, promises to pay their members legal expenses if their member is involved in a use of force event, and those expenses start big and get bigger fast, folks. For example, imagine a case where you were threatened, you displayed your gun, you didn't fire a shot, didn't hurt anybody, and now you find yourself charged with aggravated assault with a firearm, typically a 10-year felony. If you're charged with aggravated assault with a firearm, you're looking at a retainer to your lead counsel on the order of $30,000 to $50,000, and that's just for pre-trial work, folks. That's not even for going to trial. If it's a killing case where you're charged with manslaughter or murder, you're easily looking at $100,000 or $200,000 pre-trial expense, and just multiply that for the trial itself. So if you don't have that kind of money stuffed in your mattress, just in case you're compelled to defend yourself or your family, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight the legal battle the way you want it fought, as if the rest of your life depended on it, because really it does. And that's what CCW Safe offers to do for its members. Now, there are several companies out there that offer similar services. I've looked at all of them, as you might imagine, and I found that CCW Safe is the best fit for me. Personally, I'm a member of CCW Safe. My wife, Emily, again, is a member of CCW Safe. One of the biggest reasons I favored CCW Safe over other similar offerings is that many of those others simply don't provide the level of resources you need for an adequate legal defense. If you're looking at a self-defense insurance program that caps out at $150,000 or $250,000 for criminal legal defense, that's simply not enough for a murder or manslaughter trial if you've killed someone in self-defense. In contrast, CCW Safe promises to pay what the defense cost, period, with no such cap. Having said that, CCW Safe is the best fit for me. Whether they are the best fit for you is something only you can decide. But I do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. And with that out of the way, here's my interview by CCW Safe on my thoughts on the Kyle Rittenhouse trial. Enjoy.
Welcome to the CCW Safe podcast. I'm Rob High, joined today by Philip Naiman and our special guest, Andrew Branca. Welcome, gentlemen.
Happy to be here.
Merry Christmas.
Merry Christmas, indeed. Yes.
We got to have the honor to have Andrew do some day-by-day postings for us following the Rittenhouse case. And even prior to, I thought it was fantastic the way you took charge by charge by charge and went elements of the crime and the things that we could observe, at least at that time, and see the things that had been done. And I thought you were like spot on. I thought you did a fantastic job on that piece.
Oh, very kind of you.
But I know we were on a couple of weeks back with Don, and I just wanted to kind of touch base with you again, kind of a follow-up and summarization of the Rittenhouse trial. And I'd like to know kind of your thoughts and opinions and your takeaways and kind of summary. So,
well, I mean, the prosecution was really a joke from the start. It was the prosecutor's narrative of the case was full of lies and deception and misrepresentations from the opening statement forward. it was ultimately based around this drone video footage that the evidence fairy dropped on the prosecutor's doorstep midway through the trial that the defense had never seen before. It was presented to the defense in I can only describe it as a doctored form, a degraded form in terms of its resolution. And folks, that's no different than if the evidence was 10 pages of typed paper and the prosecution gave them only 3 of those pages and not the other 7. That's the equivalent here. So they gave them, and of course the defense looks at that low resolution footage, can't make anything out of it, figures we don't have to worry about this. And then in court, the prosecution shows the jury a high resolution version, which, by the way, you really can't see anything in that one either. So then they present enhanced versions of the video, still photo captures of the video, enhanced versions, zoomed in versions. This is a trick I see prosecutors do a lot when they have a case where there's no legal merit, is they take one piece of evidence and then they present it in a dozen different ways to make it seem as if it's a dozen different pieces of evidence that you should give greater weight to. It was all only the drone video, but they presented it in so many different forms and versions and video and stills and zooms and enhanced in an effort to give it far more weight than it actually did. And then what they did present was supposedly Kyle Rittenhouse engaging in what's called provocation with intent, pointing his rifle at someone, they claimed. And you really can't. The picture was of such a low clarity that it was like one of these pictures they used to have in the malls around Christmas time, where you'd have to unfocus your eyes and an image would come out of the dots, or these images where some people see a horse and some people see a woman. It's whatever your mind wants you to see in those pixels.
Rorschach test of evidence.
It was just absolutely terrible. And of course, we're talking about someone's life here, the rest of their life in a cage, based on this ambiguous, ephemeral form of video, and just hoping that the jury is going to buy it and convict this young man of horrible crimes that'll put him in prison for the rest of his life. It was really utterly contemptible.
Well, and a lot of our members don't really have a full grasp on kind of the rules and ethics of conduct regarding a criminal proceeding. And as an investigator, I had to have all of my stuff together to the prosecutor within a timely manner, and they would go through this stuff, and then they'd provide that through discovery to the defense counsel. And that has to be done, at least here, was at least 2 weeks prior, which is, as well as I do, is no time at all.
No.
Especially when you get somebody that is trying to kind of fudge their way through a case, and all of a sudden they include all this other crap.
Right. Thousands of exhibits of evidence, most of which are irrelevant, but which the defense now has to review each and every one of those.
And people don't get that. I've done hundreds of hours of review on documents that came in through discovery that were just paper ream boxes full. And because there may be something important there,
right,
you can afford to not put eyes and read everything that comes in.
And it's not just in the form that you're seeing it. It's, well, what if they magnify this? What if they modify it? What if they do look at it in a particularly odd way? They're going to claim they provided that to you under discovery. You had that piece of evidence. I mean, I've seen it happen. Don can tell the story from the George Zimmerman trial. There was evidence from Trayvon Martin's phone that was burned onto a DVD. And what happens, of course, is you have thousands of things burned onto the DVD. So they also provide a written summary report of the contents of the DVD. So you don't have to look at each item digitally. You can kind of scan the written report and see if there's anything that looks interesting there. Well, what the prosecution did was they provided the digital version on the DVD, but they did not include it in the summary report. So when you review the summary report, you don't know it's on the disc. You're relying on the prosecution's representation of that evidence. And then when you get to trial and suddenly it pops up, the prosecution says, well, we gave it to you. I mean, I guess in a sense they gave it to you, but it's like they wrote it in invisible ink on a piece of paper. Theoretically, it's there. If you knew to hold the paper over a flame, the ink would become visible. But if you don't know that, you're not constructively informed of the availability of the evidence. It's contemptible conduct by a prosecutor. And by the way, folks, the standard for prosecutorial conduct and defense conduct is different and ought to be different. The state has all the power here. The state is supposed to be seeking justice, not just a win. They're not supposed to be ambushing a defense with surprise evidence, suddenly discovered evidence, evidence in a new form that no one ever saw before. They're supposed to be disclosing everything, presenting a clear narrative of why they believe this person is guilty beyond a reasonable doubt. The defense can be sneaky and ambiguous and deceptive and all those things. I don't think the defense has any obligation to return discovery. If I had my way, there would be no such obligation. The burden's on the state. It's up to them to meet their burden. They have to present discovery to the defense. The defense should not be obliged to do anything in return until they're actually at trial, where there would or would not present a defense. That's up to them. But the standards of conduct are completely different. The prosecution is supposed to be seeking justice in a broader sense. The defense is supposed to be holding the state to its burden to prove their client guilty beyond a reasonable doubt. Those are two completely different things.
Andrew, if I could ask you a quick question here. The document dump that happens, right? 25,000 pages, and you have 2 weeks to go through them. This is why it's so important. If you are in a case like Kyle was, fighting for his freedom, right? Fight for your life, fight for your freedom. We talk about this all the time. You need to have the ability to have a legal department behind you that has the means to go through 25, 30, 40,000 pages of junk dumped on you in 2 weeks. And if you don't have an unlimited coverage, you're going to run out of money. You're not going to get the defense you need in the time you need it.
Yeah, and it's very easy to overwhelm the defense. I mean, a normal criminal defense, like we look at this Kim Potter trial, it's really 3 lawyers on the defense team, and that's about it. And if they're presented with hundreds of hours of video to review, and you can't just hire a temp to look at this stuff, it has to be someone who's knowledgeable about what the legal issues and arguments are going to be. That's a high value person that's going to be very expensive. And now they have to watch all this video. But if you don't do that, you get ambushed, you get crushed. And there's other ways the prosecution does this too. It's not just with evidence. If you look at, for example, the Derek Chauvin trial, he basically had one attorney and an assistant on his defense. And the state had, I think they had 9 attorneys, maybe another 3 who were also admitted onto the case. And the prosecution had 9 attorneys, another 3 admitted on the case. And the prosecution was churning out motion after motion after motion. All night they'd have people writing motions. Well, the one defense attorney was in court all day. He doesn't even have time to read those things until the end of the day. And then he's supposed to write a response, a 20-page response that night, and come back to court prepared to argue the law again. It's an impossible burden unless you have a defense team that's enormously well resourced to be able to meet those demands.
Absolutely. And that's one of the things. It's hard to get your mind around it, right? Everybody has their own filters when they're looking at life. My frame of reference is this, right? I don't do these things, so I don't imagine that anybody else does. We run through that in our lives all the time. And we never imagine, I've never imagined the prosecutors to act the way I saw them act in the Kenosha case, that they absolutely were just going over and beyond. I mean, they weren't trying to press the case. They were trying to create things. Right. And at that point, you realize that, holy cow, when the state decides to do a political job on you, just like this other case, the Chauvin case, 12 lawyers to 2, they can just overwhelm. They have unlimited resources. And we don't even believe that happens. And then all of a sudden, boom, we see this happening.
Yeah. And to be fair, 99.9% of prosecutors and 99.9% of prosecutions are not run that way. I mean, most prosecutors are well-intentioned civil servants seeking justice, trying to protect the community from bad actors. But they have the power to do this if they wish, to overwhelm a defense with improper legal argument, with irrelevant evidence. We give prosecutors enormous power and discretion. And when it's used prudently with a sense of justice, it's not a problem. The trouble is when you elect to those positions of power people who lack the ethical framework to apply that power in an ethical way, you end up with these really egregious cases. And unfortunately, some political actors have discovered how cheap it is to buy prosecutors' seats. I mean, these are positions where normally in most jurisdictions, your local prosecutor's been there for 20 years, 25 years. He's a well-established member of the legal community. Everybody knows him. No one's really running against him. That's just not really done. If there is a competitive race, they're spending $2,000, $3,000, $5,000 for that race. Well, if somebody comes in and dumps $500,000 into that race and buys TV time and newspaper advertisement, well, that's how old I am, Facebook advertisement, I guess. they've just bought that seat. There's no way the established guy can compete with that. And often the people who are getting that kind of funding are politically motivated actors who are intent on using that power of that office for political purposes.
Yeah, we're seeing that, and not only in California, we're not only seeing it in those kind of prosecutions, but in the lack of prosecutions for horrible crimes that are just allowing to go unseen. In Sacramento, not Sacramento, in Seattle, the public defenders there aren't making plea deals because whatever they would have asked for is more than what the DA is coming back and offering them. So they say, okay, we'll go for 6 months. DA comes in. How about time served? It's like,
yeah,
those things are happening.
Well, and Andrew's talking about the volumes of stuff you can overwhelm a defense team with. Something that a lot of people don't understand is as an investor, you'll have to turn over things that might not be favorable to the prosecution. If I come across something that we're working a case against Phil, just
again,
and all of a sudden I come across this deal that, like, man, he may have something over here. I have to turn that across. I gotta let the defense know that exists.
Right.
It's a whole fairness thing, and that's the one thing that we didn't see in the Kenosha case. It was just we should never do this as all our final goal is a victory. That's not what this is about. It's finding the truth, and it's not for me as an investigator to establish, and it's not for Andrew as an attorney to come in and do. It's we're going to give you all the sides of this and let a jury of our peers make that decision. Andrew, I don't know if you'd seen the stuff going on outside with, Phil and I talked about this earlier. A guy that calls himself some type of honorary nephew of George Floyd or something, and he's broadcasting stuff live from his car. I mean, he's live streaming, and he's talking about, we have people in the courtroom. We know who the jurors are. They better come back with the right decision. And that kind of tampering, I don't know why you didn't write a warrant and go after that guy right then.
Yeah, you ought to. I mean, I'm aware that stuff happened. I don't follow that out of court stuff closely because, of course, I'm really doing a legal analysis. So I'm trying to restrict my framework to what's actually happening inside the courtroom. But I hear about that stuff, even though I'm not looking for it. One can only imagine what the jury's hearing, yes, even though they're not looking for it, if they're abiding by the judge's instructions. But it's, we live in an internet age. You're exposed to everything. When I started as a lawyer, you could just tell a jury, hey, just don't watch the 6 o'clock news, and they'd be pretty protected from hearing anything about the case. But now we're all immersed in our social media. We're all exposed to information all the time that we're not seeking out. It's pushed at us. So it's almost impossible unless you tell jurors you're not allowed to use the internet for the next 3 weeks, which to most modern Americans would be, a catastrophic emotional event for them. So judges just don't do that.
Yeah, it's unbelievable. And to me, that still should be the most protected part of the whole show is ensuring our jurors are safe and protected and don't have these morons coming behind making veiled threats or direct threats or whatever.
And it's only going to get worse, folks. So this problem's not getting better on any level. So the problem of politically motivated prosecutors, this is all win-win for these guys. There is no downside to them. Either they win the case and they get a conviction, like, by the way, we just got in the Kim Potter trial a few minutes ago, convicted on both counts of manslaughter. So they've won the conviction. That's a win at trial. Or they lose at trial, like in the Rittenhouse case. But they've won politically. They've won within their social community. They fought the good fight. They did the best thing they were able to do. It didn't result in a conviction, but at least they tried. Those people get book deals. They get CNN legal analyst gigs. They get promoted. They run for office. I mean, the guy who was the prosecutor there had already run for DA in an adjacent jurisdiction. He lost that race, but he has a much higher profile now than he did in the last race, and he'll run again. And by the way, in a few years, Judge Schroeder in the Rittenhouse case did a great job of mostly keeping those prosecutors in check, not from their worst abuses, however, but from many of their lesser abuses. But in 5 years or 10 years, that's not Judge Schroeder on the bench. That's Judge Binger on the bench making those calls.
The other thing is, when they act like that, we say, why are they doing that? But that's ensuring the next $500,000 donation to run for their case. They're plying their masters, right? The one who's giving them $500,000 to run their case. That's what he wants them to do. That's what they do. Guess what? They get another $500,000 to run for that.
Right. So maybe Binger didn't have a $500,000 funding last time, but maybe he gets it next time because now he's on their radar screen or as a warrior for their cause.
He'll get it for his judge, running for judge.
Right.
Yeah.
Well, it's like the other Wisconsin case, the Christmas Day parade with the vehicle going through the crowd, very purposely going through the crowd. And the guy immediately, people start looking at it. It's like, this guy's out on bail and he just, he why is he even out? He should be locked up. And you have a prosecutor in that jurisdiction, the present DA, who ran on the platform of getting rid of cash bail and cash bond. And we're not going to do that anymore. It's not fair. And then as soon as great publicity hits this thing, he is like, we're going to get down to the bottom of this. I'm going to find out who let this guy go. And it's like, you did.
Right. For a moment, he's talking about it because he's feeling some political heat, but you don't see that case getting nearly the coverage in the mainstream media, not necessarily the media we see, folks. We have to be very aware of this. Social media puts all of us in bubbles. So they only send you information that they think you will like or will get you energized. The other, the rest of the world is not seeing the version of the news that you're seeing, and they're probably hearing nothing about Waukesha.
We just had a case in not in California. We had somebody released from a psychiatric ward from California, went to Idaho, killed a 70-year-old man, and cannibalized part of him. So it comes back to this, Rob and I talk about this all the time, is why is there no responsibility on the people who let them out? Somebody said, hey, this guy's good, right? Just like the person who did the car, hey, he can go out on no cash bail. It's no problem. These are good people. We should put them back out on the street. They're trustworthy. They had a school shooter, shot 4 kids. He's out the next day. The people who put these folks back on the streets, they have blood on their hands. And I don't know why we are not able to hold them accountable for the decisions they make that put the rest of the people at risk.
Right. Well, we need to distinguish between, what requires societal efforts to hold people accountable and what's within the realm of individual accountability. We can't hold responsible as individuals. We cannot hold responsible the people who release these monsters without bail or out of institutions. There's nothing we can do to hold them accountable. Societally, we can. If we decide to elect different people to government, we'll get different outcomes. But as an individual, Andrew Branca has zero ability to hold those people accountable. What I do have the ability to do as an individual is, 1, be prepared to defend myself and my family, be armed. 2, do everything within my power not to have to use those tools if it's possibly avoidable. And 3, if it's not avoidable and I'm compelled to use those tools, make sure I'm also well positioned to win the legal fight, just as I was well positioned to win the physical fight.
Yeah.
You're singing our song there, Andrew.
Yep, absolutely. I mean, that's why I'm a big fan of you guys.
It's one of those things that, we talk about it pretty frequently about the benefits of membership with CCW Safe. I don't think the average person really comprehends what a big deal it is to have a jury consultant, to be going through this stuff as we're going through jury selection and questioning, and it's got to be on point right then. I mean, it's in the courtroom working aggressively, very active. Because if you don't do that, and all of a sudden you get 2 people on there that are absolutely biased, they can't be fair and objective, and you're in trouble. I mean,
it's every facet of the game. So if you imagine it like the trial itself as a football game, how that playing field is defined, the dimensions of it, what you have to do to score a goal, all of that, that's defined slightly differently for every trial. And that's all defined in the pre-trial process. What evidence will be allowed, what legal arguments will be allowed or not allowed. Those arguments are made before a judge. And each side argues their position on a piece of evidence or on a legal argument, and the judge makes a decision. And that's it. It's over. So your lawyer doesn't get to think later that night, oh, if only I had argued X instead of Y, we might have had it's too late. You've got to win in the moment. And the jury is the referees
DA, right?
on that playing field. So if you get bad referees and you're making those decisions, again, in the moment, you don't get to think later today in the evening, oh man, if only I had asked that prospective juror this question or that question. It's too late. It's too late for that. So you
Unless
need a quality of
DA,
legal team that
then you can just bring
that.
it up anyway, right? If you're Kenosha, you just bring it up anyway. Yeah,
right.
just taint the jury and run with it.
Well, again, the judge did such a good job. He at one point in time when Binger goes after Rittenhouse for not making a statement, all of a sudden now you get to see what else is going on. And holy
for crap, seeking legal counsel.
that was as wrong can be, and a lot of people don't understand that the rules are in place for a very specific reason.
That actually did catch a lot of us by surprise that we didn't realize you couldn't do that. Andrew, would you kind of touch as to why that was there?
Yeah, no, you have an absolute right to legal counsel, and the fact that you sought legal counsel cannot be used against you in a court of law, cannot be mentioned before the jury, and it's the same with your right to remain silent. You have an absolute right to remain silent, cannot be used against you, cannot be mentioned in front of the jury. These are very, very old, well-established legal principles in American law. Anyone thinking that the prosecutor didn't realize he was misstepping there has no idea how this game works. He absolutely knew that it was strictly prohibited for him to mention either of those things, and he did it regardless, because the point wasn't really the answer he was going to get to the question. The point was the question. The jury was going to hear the question. That's why you're not allowed to mention it in the first place. And he knew that, and the judge got very upset. Frankly, it would have been perfectly legitimate grounds for a mistrial with prejudice, which means not only is this trial over, but the prosecution's not allowed to try you again on the same charges. Ultimately, the judge decided not to go that direction. Now that we know what the outcome is, that works out fine in hindsight. I mean, we know he got acquitted of all the charges, but you don't know that at the time this decision is being made. That was perfectly legitimate grounds for a mistrial with prejudice. Which the defense asked for, but didn't get. I mean, in a sense, now that he's been acquitted, it's better because people would always say, "Hey, if it hadn't been for the mistrial, who knows? Maybe he would have been convicted." Now we know that's not the case. We know he was acquitted by the jury on every single charge unanimously. So it worked out well for him. But it's a high stakes game, folks. Nobody knew when that verdict was being read what it was going to be.
Well, absolutely, Kyle didn't. I mean. Right. When he finally got that last not guilty, I mean, he'd been holding it together. And
his lawyers didn't. You could see it on their faces when the jury came back into the courtroom. They didn't know what to expect at all.
They weren't quite as shocked as Shapiro when OJ was not guilty.
Yeah, well,
he couldn't believe it. He's like, what?
That trial's a case study all in and of itself.
Yeah, absolutely. OJ didn't believe it. If you remember his look, it was just like, huh? Oh my God, we won.
He started running through airports again, jumping over luggage.
The choice to put Kyle on the stand, in my opinion, is if you're going to go with self-defense, you almost really don't have a legit shot if you don't go on. But to go on with such a young man and to be as composed for the most part as he was, what were your thoughts?
Well, it's extremely high risk, right? So there's really three reasons you don't put your client on the stand if you're a criminal defense attorney. One, the most common, is that he's actually a criminal. I mean, most criminal defendants are criminals, and so they have a criminal background, and all that can be brought out in court once they're on the witness stand. It's just character evidence, and any witness's character can be attacked for credibility and a variety of other reasons. Of course, Kyle didn't have that problem. He was squeaky clean. So that one's checked off. We don't need to worry about that. But there are two other risks that are unavoidable, even if your client is squeaky clean. One is that a skilled prosecutor, by being snide and sarcastic, will get them to have some kind of outburst on the witness stand, respond with anger, which is very, very bad in the self-defense case, because then you just look like an angry person, right? Which is what the prosecutor is trying to sell you at. You want to look as the most reasonable person there. And the third risk is that, a smart prosecutor, and whatever you may say about Binger, and I don't think much of him as a human being, but he was a good lawyer from a technical perspective. He knew what he was doing as an attorney. A good attorney, a good prosecutor, and a good defense attorney, they're always thinking about the closing. What is the narrative they're going to sell to the jury at the end, just before the jury goes into deliberations? They have a story in mind that they want to be able to tell, but that story has to be built out of building blocks of evidence and testimony. So through the whole trial, sometimes you'll hear a lawyer ask a question of a witness. It's like, well, why would that matter? Well, it may not matter in the moment, but it may matter as one of the building blocks for a larger narrative he's planning to create for the closing argument. And they may ask what seems like basically the same question in slightly different ways, because what they're trying to do is get a response containing very specific words out of the witness, words they can say, even the witness himself, even the defendant himself said this, and then repeat those 3 words or 4 words or 5 words, usually out of context, but in a way that makes them look very bad. And while Kyle Rittenhouse didn't have to worry about the reputation problem, because he didn't have a bad reputation, when they put him on the witness stand, his lawyers never know if they're going to encounter the outburst problem or the carefully selected words out of his mouth problem. You have no control over that. You can tell the defendant to remain calm and not engage in an outburst. But listen, Rittenhouse was subject to 3 hours of cross-examination. It's hard to remain calm, especially when you listen to the tone and the nature of the things that Binger was saying during that cross-examination. And if you go back and watch it, you'll hear Binger ask the same question 4, 5, 6 times in slightly different ways, because he's looking to drag those specific words out of Rittenhouse. And Rittenhouse, unlike Binger, who's a professional interrogator, that's his job, Rittenhouse is just a kid. He's an 18-year-old. He has no idea what those words are, how damaging they could be. And so as a defense attorneys, you cannot protect your client against those second 2 risks. So no matter how clean your client is, you're encountering those risks. Now, I think Rittenhouse did great. It worked out fine. I don't think he damaged himself. I think he presented very well in front of the jury. But you don't know that going in. That's the fortunate outcome we got at the end. So very, very high risk. As it happens, it worked out well. I mean, he's a remarkable kid.
The thing that Binger had as far as his building blocks for his closing, I thought was unique, that one of the building blocks of evidence is an AR-15. So if you just rack it, point it at the jury, and wave it around with your finger on the trigger, that's a pretty good building block of evidence if you want to try and intimidate somebody. I'm just thinking. Maybe it's just me.
Most people, I shouldn't, we're all gun people. So guns don't bother us. They're comfortable to us.
Right.
They're comforting to us.
And it would have just made us angry.
But for people who are not gun people, a gun is like a rattlesnake in the room. I mean, it's terrifying to them. It's inherently dangerous. They could look at it wrong and it could discharge and kill somebody. That's how they feel about it at an emotional level. And of course, the prosecutor is going to press all those emotional buttons. It's going to rack it. It's going to point it. Sometimes they pull the trigger. I mean, it's unbelievable.
You're absolutely right. And again, it's an intentional thing. And that's, we could just come down to this time and time again. Your defense after a fact, even the legitimate, and I don't think we've seen an online or a video of a more obvious self-defense case than Kyle Rittenhouse. That probably should have never gone to trial, but they will. They're going to go to trial. And, if you don't have the protection in your house, you're going to lose everything you own. And hopefully you'll have a defense team that can cover you, or you can go to ccwsafe.com, fix all that.
Yeah. I mean, people need to understand how expensive these things are. I mean, when I consult on a killing case, a manslaughter or murder case, it's extremely common for the defense to burn through a couple $100,000 before they ever get to trial. Very common. And of course, if you don't have that kind of money, don't have those kinds of resources, well, then you don't spend it. You don't spend what you don't have. And by the way, the lawyers don't work for free, folks. So, when I consult on the case, I get paid up front. That's just the way the system works, because I know I won't get paid after the fact if I'm not paid up front. And if you don't have that kind of money, well, that's fine. But there's an unbelievable difference between a $200,000 legal defense or a $400,000 legal defense and something that's 1/10 of that. If you just look at the Kim Potter case or look at the Rittenhouse case, you'll see these use of force experts brought in. The state gets all those experts for free. Their experts are free for the state. It doesn't cost them anything effectively. So if you want to counter their experts' testimony, their firearms examiners, all that stuff, if you want to counter that, you have to bring in your own experts. And those experts are costly. Frankly, I'm costly if I'm involved in your case. But if you don't have them, the jury only hears one side of the story. And if you've ever heard an argument from somebody and you only hear one side, it always sounds pretty compelling until you hear the other side. So you better have the resources to present that other side, or a jury's going to arrive at a verdict that's maybe unjust, but is not surprising given that they only heard one side of things.
Well, you've met our team, our guys. Gary Eastridge is our critical response team manager. Gary's brilliant. And he has, for 10 years, he was the chief investigator for the district attorney's office here locally. And we've seen cases, we're talking about Kyle invoking his right and not sitting down to be questioned and not doing anything without an attorney present. I never had an issue as an investigator sitting down with a client or, with the defendant and their attorney. I got no qualms with that. If you want to sit in there, that's fine. I'm not doing anything that's shady that I shouldn't be doing. But I'm telling you, there's been some huge cases that Gary sat in on, and it's exactly what you were talking about, Andrew. You get a professional interrogator, and they're just hammering and hammering and hammering.
Which is what detectives are too, right? And by the way, when I say that, folks, I don't mean in a derogatory way. This is their job. This is what we pay them to do. So they're only doing what they're supposed to be doing. But they are literally professionals. We send them to school to learn how to do this.
Yes, absolutely. And Gary has been the guy that has to review some of those cases as they're coming in. You get the prosecutor that says, take a look at this real quick, and he does. And all of a sudden it's like, oh my gosh, this is a false confession. And you go back and you look at it, and you've got an investigator that really is either completely untrained or just totally blatantly violating their sworn oath.
Yeah. Or you get a suspect, and if you're badly motivated as an investigator, you get a suspect. And frankly, it's not that hard to tell that this is someone that you're going to be able to steer around. Yep. You're going to be able to point them where you want them to go.
Again, that's why we tell our members, I don't want you to be crass or not I don't even want you to be impolite, but right. If you are involved in an incident, let them know that, listen, I'm very shaken up. I've just been through this horrible ordeal, and I would absolutely like to sit down with you and give you my side of the story, but I want to wait and make sure that I don't do anything to get myself in trouble. I'm going to wait until my attorney's present.
Yeah, honestly, I would just do that last part. Obviously be polite. Yes, sir. No, sir. Yes, ma'am. No, ma'am. All of that. Obviously be compliant. I mean, it's not up to you if you're going to get arrested. That's up to them. No one does not get arrested because they don't want to be arrested. That's not how it works. Be compliant, be polite. But just say, sir, I really, before I talk to anybody, I feel like I should speak to my attorney.
Yeah.
And then if you remember CCW Safe, call CCW Safe. That's what the number on the card is for.
Yeah. And you're going to probably go to jail for a while. They're going to put you in cuffs, take you away because they don't know what's up. That's
the least important. 20 years from now, that'll be an interesting story you tell at parties.
Right. So you're not going to be able to talk your way out of going downtown by saying, so don't. No. You're going to take the ride, wait for your attorney, say some prayers,
I wish people would not worry about that. It's one of the most common questions I get. What can I say to avoid getting arrested? And it's like, it's so unimportant. It's so inconsequential. What I'm worried about is, are you going to spend the rest of your life in a cage with unpleasant people? That's the fate we're trying to avoid. And anything you say in an effort to try to not get arrested, only jeopardizes our ability to keep you out of that cage for the rest of your life. So just don't worry about it. It's not prison. It's just a jail. It'll be fine. Don't worry about it. Don't stress over it. And as I say, years from now, it'll be a story that you tell at parties.
Yeah. Andrew, thank you so much for coming on and helping us out. We sure do appreciate your insight into this thing. Again, guys, we always welcome your comments. You can go direct to me, Rob, at ccwsafe.com. We appreciate all of you that are our members. We're honored to serve you. And we look forward to seeing you next time. Thank you, guys.
Hey, will this go out before January 8th?
Yes.
Can I mention a class I have coming up?
Yeah, it's next week.
mylawselfdefense.com/advanced class, lawselfdefense.com/advanced, Saturday, January 8th. We only do it once every year or a year and a half, folks. So if that's of interest, take a look.
Thank you, guys.
Thank you. God bless.
Bye-bye.
Okay, folks, that's all I have for you on this particular topic today. I do, however, want to invite all of you to join me tomorrow, meaning December 30th, 2021, to participate in our first ever live YouTube stream happening tomorrow at 1 p.m. Eastern Time on the Law of Self-Defense YouTube channel at youtube.com/law of self-defense. We've never previously done the YouTube live stream thing, but after being on a bunch of live streams hosted by others, mostly lawyers, and hat tip to Nick Warkaida in particular, I thought I'd give it a try and see how it works. I've got 3 topics I plan to cover tomorrow. First, the Burlington Coat Factory shooting by police in North Hollywood, California, which occurred this past Thursday, and in which a 14-year-old girl was accidentally shot and killed. Second, the interview just published today of one of the Kim Potter jurors. Third, a Potter-like officer accidental use of a gun in place of a taser incident that occurred in Kansas in 2018, in which the officer involved had reckless manslaughter charges dismissed by the trial judge in a manner and on grounds that ought to also have occurred in the Potter trial. As most of you probably know, I'm mostly an idiot about all things internet, so it's quite possible tomorrow's first ever Law of Self-Defense live stream will be a train wreck. But if you'd like to see it happen in real time, tomorrow at 1 p.m. Eastern Time would be the chance to do that. Again, you can join that live stream tomorrow, December 30th, 2021, at 1 p.m. Eastern Time at the Law of Self-Defense YouTube channel at youtube.com/law of self-defense. It's my expectation that the show will last no longer than an hour, but we're kind of playing all that by ear, so we'll see what happens. If tomorrow's show goes reasonably well and is reasonably well attended, we'll plan on doing this live stream type content on a regular, probably weekly basis. Until tomorrow then, remember, if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill, my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. I remain attorney Andrew Branca for Law of Self-Defense. Stay safe.